Good morning, everyone, and welcome to our annual Employment Law Seminar. And this morning, I'm Victoria Templeton, and I'll be leading the seminar, and I'm supported with Sue Watson, our Operations Director. So thank you for joining us. For those of you who aren't regulars to our monthly webinars, Sue and I take you through the webinar, and during which we will discuss the topic and how it may impact on your business. So what we tend to do is, from a few housekeeping points, just wanted to let you know that first of all, you'll all receive a copy of today's slides. We'll also be sending an email out after today's event where we'll provide links to further information and key guidance documents. This seminar is also recorded, and so it's going to be made available so you can play back as you need, or even share with managers in your own business. And with the Easter break coming up, then obviously this will be next week that these get published to you. So continuing with our housekeeping, because we have so many of you today, we've had to place you all on mute. However, we do want your involvement in today's seminar. And we'll do that by inviting you to ask questions throughout the morning. And what you'll see on the screen now is an image of what your GoToWebinar question panel looks like. So please type your question in, and then we'll aim to read out and answer as many as we can. There's a couple of opportunities throughout the session where we'll check on the questions, but mainly all questions will generally be at the end as well. So please do let us know your questions. And another way in which we'll get you involved is through the use of polls. And so you'll know when we're about to run one because you'll see this slide. Polls are really helpful, not only to the running of our seminar, but actually we find that it helps everyone to gain an idea of what other businesses are doing or thinking on a particular topic. They are confidential. We just know the numbers of how a question is voted on. So I'm going to hand over to Sue because we've actually got 3 quick polls coming up.
Okay, so let me launch the first one. It's a little bit of getting to know our audience today. So we'd really love to know, are you a current client, first of all? And we will share these results with you. So I'm going to close and share those results. So wow, 78% of you not, so welcome. It's lovely to have you on board.
Welcome to our clients, yeah.
Absolutely, it is all of you. So then the next little poll is, have you attended any of our webinars previously? Okay, this is another brilliant number. So 60% of you have actually joined our webinars previously, so welcome back.
Yeah.
It's lovely to see you. And then the last slide in this section, the last poll, sorry, is how did you find us? How did you get to know about our seminar? Okay. I'll close and share those. So most of you signed up to our newsletters. But great, absolutely great.
Brilliant, yeah.
That you've found us, so welcome. Thank you for that. So I'm going to hand you back over to Victoria to take us through the next bit.
Okay, brilliant. And it's really just to introduce ourselves to those of you who are new to our webinar seminars. So we are a multi-award winning HR, health and safety and payroll provider. So as experts in our fields, we deliver pragmatic support and advice to our clients, and we've done so for more than 20 years. We support clients across a wide range of sectors and sizes, ranging from small care agencies to multinational technology firms. So we have a lot of experience with many different organisations and contexts. And our growing team of expert consultants, advisors and administrators all have extensive experience in HR. So we do pride ourselves on service excellence, which is why our clients choose to stay with us. So that was just a little bit about ourselves for those of you who are new to our seminars. And really, just to now kick on with the webinar seminar, it's actually quite a full agenda today. We'll begin with the more straightforward of things, and that's to go through the latest statutory rate changes. And then we're going to focus on the employment law for 2024, and there is a lot to talk about. And once we've done that, we're going to then look at what's on the horizon when it comes to employment law. I'm going to just highlight some really interesting case rulings towards the end, and then when we finish, we have identified what our top 7 recommendations are for employers in how to prepare the business for this year, because it is a significant year when it comes to employment law developments. And then again, we'll have an opportunity to take your questions and discuss those. So, as I said, we'll start off with the most straightforward things. And here we go. So, as you know, each April we see increases to statutory rates of pay, and as you'll see here, it's highlighting what the national minimum wage is going up to, statutory sick pay, all of your family friendly payments, and the lower earnings limit. Just one thing on the national minimum wage that you may spot is that the bandings have changed. So this, if you're a small organisation and you pay the minimum wage, this is obviously something really important to factor in from a budgeting point of view, because clearly what's changing is, instead of it being from the age of 23 years and above, it's now the band becomes 21 years of age and above, so it captures more people in that higher rate. And when we look at statutory payments, when it's more about tribunals and employee protection rights and things like that, what you'll see here is the various elements. So, for example, lower earnings limit, we use that in a variety of ways when we're calculating family leave payments, implementing the that ban that we have on exclusivity clauses, etc. So that's remaining at the 1, 2, 3. And then, as you can see here, we have had increases to the statutory guarantee payment of £38 a day. That's where, and we probably experienced it a lot during the lockdown and COVID, that's where if you need to temporarily lay people off or move to short-time working. And then the maximum week's pay for things like your redundancy, unfair dismissal, basic awards, that's increasing to your 700. And then there's also increases to how tribunals award in regards to ordinary unfair dismissal and a basic award for specific types of automatic unfair dismissal. That's the area where you don't need the qualifying service. So, for example, your health and safety. And then just to also highlight the amounts for other claims. So you breach a contract, that remains at your 25,000. Discrimination, as we know, is unlimited. And I've noted here below the Vento bans. That's the guide that tribunals use to determine a fair amount to be awarded to employees when they've been discriminated. And so you've got those a 3-tier system depending on the severity and the extent of that discrimination that's taken place. And you'll note here as well that actually failure to follow codes of practice and things like that are significant. It means that employers can see the rates increase by up to 25% where there's been that unreasonable failure. So I said that was more the straightforward one, area of employment law. They're the annual changes. As I said earlier on, slides are coming out, so you'll have a copy of those next week. So we're going to move on now to the bulk of employment law that's coming in this year. And what I think is helpful, first of all, is to run a few polls, because it really gives us insight into, you know, how this particular area could impact on your business and help steer the seminar today. So over to you, Sue.
Okay, so our first question is about What type of contracts do you have in your business? What type of workers do you employ in terms of the non-straightforward
Yeah,
contractual arrangements? This just helps us gauge the impact
yeah,
of some of the regulations that are coming in on our audience. Okay, I'm going to close that poll and
yeah.
share the results. So a
Okay.
lot is fixed-term workers and
Yeah,
quite significant around the irregular hours workers as well. So
yeah. And we'll go through some significant developments that will impact you this morning.
both
So,
of those.
yeah.
So let's look at the
Thank you.
next question, which is, how prepared do you feel about the forthcoming developments? Many of them. Okay, I'm going
Yeah.
to close and share those results. So, oh
Okay.
wow, well done. So
Yeah.
many of them feel pretty well prepared, but there's still a significant number that
Yeah.
could do with some help. So hopefully by the end of this, you will feel a little bit more comfortable in what needs to be done, and we can perhaps help you get there quicker.
Yeah.
So
Absolutely.
the final slide is, what steps have you taken to prepare for the changes? Okay, I will close and share those results. So mainly the documentation, which is
Yeah.
great. Yeah, they've all needed a lot of attention. We're frantically working through all of those. For those clients
Yeah.
who are on this call, we are working through them, and you will be getting copies from the team during the next few days of all the updated policies and template contracts that you need, and also some comms for your employees. So yeah, it's a
Yeah.
big effort,
Big
isn't
piece
it,
of
for
work.
all of you involved in the HR for your companies. Okay, thank you. That's back
Brilliant.
over to you.
Thank you. So, just really a summary at this point in terms of what we're going to look at in this section of the seminar. So we're going to look at several pieces of new legislation that's coming in. So we're going to see a new entitlement to carers leave. We're going to see new employment where employees can ask for more predictable terms and conditions. And there are new laws coming in around how employers allocate tips and gratuities. We're also going to see many changes to existing laws. So that will be things like fines that employers can be charged when they're found to be employing illegal workers. A massive area is the reform to holiday pay and entitlement. So for those of you that have employees that work irregular hours, part year, this is a big piece of change. We're going to see changes to the way paternity leave is managed. Where redundancy is taking place, then we're going to see extended protection from redundancy for certain groups of the workforce. And we're also going to see new rules around flexible working come in. We are also actually going to see some changes to TUPE consultation rules, and I don't think TUPE has changed since it was introduced many years ago. So that's on the radar for this year, as well as there's going to become greater protections from sexual harassment and greater obligations on employers. So there is a lot for us to talk about. Please do keep your questions coming through as we go through, and we'll try and answer as many as we can. And so the first area that we want to just bring to your attention is the piece around the fines if an employer is found to be employing an illegal worker. So this is the immigration maximum penalty amendment order. So essentially, the fines are increasing massively, and they haven't increased for many years, I think for about 10 years or so. And what we're now seeing is that the maximum fine is increasing up to £45,000 per illegal worker, and I think that's an increase of about 15,000. And then where there's repeated offences, the maximum fine can go up to £60,000 per illegal worker. So they really have made significant changes to these. And just to let you know that the standard Home Office guidance document, which is the Employer's Guide to Right to Work checks, that was updated and published in February, on the 8th of February. This is a really important guide to make sure that you're following your recruitment practices in line with the ways to recruit lawfully. So it is a vital document to use. So it was last published on the 8th of February, and that's what's in place now moving forward for your recruitment. We then have a massive piece of development because of the Employment Rights Amendment, Revocation and Transitional Provisional Regulations of 23. This is significant. It came into force on the 1st of January, but it's got several commencement dates throughout this year. And ultimately, its purpose is to reaffirm European protections that previously existed via European legislation and case law prior to Brexit. What we're looking at now this year is that it's going to be amending certain parts of the working time regulations, and it's also going to be amending the transfer of undertakings protection of employment regulations of 2006. So in terms of the working time regulations, the areas that are significantly changing is in regards to working time records, as well as holiday entitlement and pay for those who work irregular hours or part year. We're also going to see changes to the obligations for how employers consult when there's 2P. So that's what's impacted by these regulations. I'm going to start off perhaps with the more straightforward, and that's all to do with the working time records. And these rules came in force back on the 1st of January. It overturned European case law, which had in recent years brought uncertainty in the area. And one of the last rulings, for example, confirmed that employers were obliged to establish a system for recording records so that the duration of daily working hours could be measured, including overtime. It was judged that without having those appropriate systems, it's impossible for an employer to determine objectively and reliably whether a worker worked in accordance with their rights, such as, your 48-hour week, rest breaks, and therefore whether the employer was compliant with working time regs. But now what this regulations are doing, it's making it less onerous for employers. So there's still an obligation to demonstrate how you're complying to the working time regs, but it's only if you can, if employers can demonstrate compliance to them in other ways, then employers won't be required to keep a record of daily working hours. It's going to be for each employer to determine what is reasonable in the context of their own business when it comes to the best way for keeping and maintaining records to demonstrate compliance. But I think what it's doing is it's making it a more a system that is more appropriate to each and every organisation based in how it operates and its business context. But ultimately, there's still that obligation to demonstrate you are complying with the working time regs, but it's a more adaptable, manageable approach. The next straightforward piece is your 2P consultations, and that's going to impact on all those 2P transfers that are occurring on or after the 1st of July. So if you're starting to plan or working towards a 2P transfer, just factor this in. So the change will only apply to those organisations that don't have existing representatives in place. And it means that for the 2P consultation, you can directly consult with your employees when your business employs less than 50, and that's regardless of the size of the proposed transfer. And it will also apply to any business of any size, but the proposed transfer is fewer than 10 employees. And they're the two areas where you can consult directly with your employees, as opposed to having to create some consultation for them. It doesn't apply where a business already has in place employee representatives and trade unions. These continue. So again, it's about trying to make it more workable for employees, especially small businesses. So now over to holiday entitlement and pay, and I noticed from the poll that there's many of you that do employ irregular hour workers and part-year workers. So the current legal position is, I'm sure you'll know, it's complicated, administratively a burden, and not straightforward. But essentially, the Harper Trust is a significant case ruling that confirmed, probably 18 months ago now, those who work irregular hours or part year are entitled to the full 5.6 weeks of paid annual leave. Now, this differs to the legal position for a part-time employee who works regular part-time hours. They still receive a prorated amount of the 5.6 weeks. So that's where you can see an unfairness there. So the Harper Trust judgment has created several challenges. How do you know what to pay someone when they take 1 week of their 5.6 week entitlement because they've got no set hours? How do you manage what leave they have remaining when they've taken some leave? Does the ruling apply to other types of contracts, or is it just one type? But like I said a moment ago, how is this fair to those who are part-time, working regular part-time hours or all year, but yet they have their 5.6 prorated? So the regulations that have come in force back on the 1st of January aims to correct those challenges brought in by the Harper Trust in particular. It comes in force in January, but there were several dates throughout this year where there are other implementation dates. So it's looking to change the position that was set by the Harper Trust ruling. They apply only to those who fall under the new legal definitions of who is an irregular hours worker and who is a part-year worker. Employers in Northern Ireland must continue to apply the Harper Trust ruling. So these new regulations are only for England, Scotland and Wales. And if you have part-year or regular hour workers that fall out of the scope as defined in the regulations, you're going to need to carry on with your Harper Trust methods. So all will become hopefully a little bit more clearer as I take you through the slides. So this slide is just summarising, first of all, what's changing. So there's going to be a change to carryover rules. We're going to have a new definition for what constitutes normal remuneration for the purpose of calculating the holiday pay. We have a new method for calculating holiday that's accrued when somebody is absent due to family or sick leave of any duration. We have definition of who is an irregular hours and part-year worker, a new method for calculating an entitlement, and an option to introduce rolled up holiday pay instead of the current 52 reference period. So that's essentially what's changing. So if I look at those one by one, and if we start off with carryover rules, so essentially the regulations allow employers to have a policy where maximum of 8 days can be carried into the next year, but obviously that's got to be with the agreement of the employer. When it comes to carryover of leave, where there's been an employee who's been absent due to a statutory entitlement, such as your family leave, so adoption, maternity, shared parental, they are legally entitled to still continue to carry over up to 28 days of statutory leave. Now, if an employee has been unable to take some or all of their statutory annual leave due to sickness, then the maximum carryover will differ depending on the nature of the person's work arrangements, as I've shown here in this summary. So if you have an employee that works regular hours all year, they will be able to carry over up to 20 days if they've not been able to take their holiday due to sickness. If you have someone that works irregular hours or part year, they can actually carry up to 28 days over into the next year. if they've not been able to take all or some of it due to sickness. Now, this, on the face of it, this seems like an oddity and it doesn't seem to make sense. And we don't actually really know the reason, the answer for this. Nothing's being clarified in writing in any of the guidance. All we can suspect is that, you know, if you think about the people that previously were, I guess, had their holiday managed under the Harbour Trust ruling, they've gone from a position of having all 5.6 weeks of leave, now they're going to a prorated element. So whether it was an element of trying to soften the blow because of that change, I don't know, that's just a theory. Or the other way of looking at it as well is that in practical terms, it's going to be unlikely for somebody who's working irregular hours part year to actually accrue or clock up all 28 days, because that's essentially a full-timer. If they did, then it brings into question what is their actual employment status. Are they really an irregular hours worker? So I think for a true irregular hours worker, where they do 10 hours one week, 5 another, have a couple of weeks of not working, they're never going to clock up 28 days. But on paper, in the regulations, they've differentiated it. So it's just about making sure your policies are complying with that. And then just to also say that the leave that is accrued must be taken by the end of the period of 18 months, starting from the end of the leave year in which it was accrued. Now, I think it's quite helpful that the regulations have defined what we mean by somebody who's an irregular hours worker, who is a part-year worker, and what we must include when we're calculating pay, because we've got now a definition for normal remuneration. So you can read on the screen here what we're talking about. So irregular hours is all about if the number of paid hours that they will work in each pay period, i.e. the frequency, weekly, fortnightly, etc., is under the terms of the contract wholly or mostly variable. And then your part year is all about, under the terms of the contract, they're required to work only part of the year. Typically, you know, school teachers, teaching assistants, term time workers. And then you've got your normal remuneration. And really, I guess it's no different to what's been happening in practice, because what's been happening in practice has been as a result of case rulings. This definition has just put pen to paper with this case ruling and really telling us what we've been having to apply already. And it's just confirming to us, it's clearly defined in the regulations now that it has to be your payments that are intrinsically linked to the performance of tasks which a worker is contractually obliged to do. So, for example, your commission payments, it relates to payments that are of a professional personal status relating to length of service, seniority or professional qualifications. And it also includes payments such as your overtime that have been regularly paid to a worker in the 52 weeks preceding the calculation date. So we have those definitions now. However, unfortunately, the regulations are still ambiguous in certain areas. And as you can see on this slide here, in the first definition, we don't really know what's meant by wholly or mostly. It places a reliance on the manager making a judgment as to whether somebody's going to fall in that definition or not, which therefore naturally then brings legal risk. You've then got equally a concern, a question, if you like, over the definition for a part-year worker when it talks about at least a week where they're not required to work and for which they are not paid. But what happens when the employee doesn't work every week but is paid in equal instalments throughout the year? Do they fall into that definition or not? It can suggest that they wouldn't. But then having said that, the only reason they're getting equal instalments of pay is because it's administratively much easier to manage. So can it be argued that they are a part-year worker, it's only because of admin reasons that they're getting a payment in a week where they've not worked? But nevertheless, it's still an area of ambiguity, and it really is only going to get may mean that we need a test case, get my words out, a test case to be able to give that clarity to us. And then if we think about the normal remuneration definition, what is meant by regularly paid. Again, it's putting that onus on the managers to make a judgment, and that's where then it's a grey area, and what if misjudgment takes place. So there are still questions, unfortunately, and we can only go by what we're making reasonable judgments based on those definitions in the context of each case. But yeah, they're just important areas to be aware of. So when it comes to calculating statutory holiday, and again, this is only for those who are working irregular hours or part year, there's going to be changes to any holiday years that start on or after the 1st of April. So if you are currently in a holiday year, so it started back in January, runs until December, you won't need to do anything until next January, because that's the start of your next new holiday year. But if you have an April to March holiday year, then literally next week is when this new method is introduced. And it will mean that you have a standard approach to calculating entitlement using what's called the 12.07 method. And for many of you, I'm sure you'll remember this from previous years when it was a lawful way of calculating pre-Harper Trust ruling. So the 12.07 method gives the worker holiday entitlement that equates to basically 12.07% of the actual hours worked in the pay period. Just to flag here at this point, if you offer more than the statutory minimum to your employees with holiday, then you need to find an equivalent figure to that 12.07. Otherwise, you risk breach of contract claims and claims of unlawful deduction of wages, because essentially 12.07 is the same as saying 5.6 weeks. But if you're giving 6 weeks, well, then it's obviously not going to be your 12.07%. So you just need to work out what is your equivalent percentage for how you calculate entitlement. We also have a new defined method for how you calculate holiday that's been accrued when somebody has been off due to family leave reasons, maternity, adoption, etc., or sickness. So this time you're still using a 12.07 percentage figure in it, and obviously you need to adapt that if you offer more than the contractual, but you need to know you need to calculate it using average hours worked as opposed to actual hours, and that's where they've introduced a new 52-week relevant period. That will then help you calculate what an average weekly number of hours that person works, and therefore determine how much on average holiday have they accrued each week. When you determine your 52-week period, you have to exclude your weeks where they've been on other periods of family sick leave for any amount of time. And then where there have been weeks not worked for other reasons, you include them. And you're essentially counting back 52 weeks. And because it's not necessarily all consecutive, you may have to go further back than your 52, but the cap, however, will only ever be the 104 weeks. Clearly, if you've got somebody that's a new starter, you go back as far as their start date, but you need to find a period of 52 weeks or equivalent if they're a new starter, to then work out what an average weekly hours are for then calculating holiday entitlement. When it comes to pay, just wanted to highlight here, as you can see in the table, there are two elements to holiday, and the government have continued with this. You have your basic pot of holiday, which is your first 4 weeks, and then you have additional holiday, which is the final 1.6 weeks. So combined, that's your 5.6 statutory weeks of holiday. What you'll see here is if you're somebody that works regular hours, full-year worker, strictly speaking, statutory wise, they are only entitled to the normal rate of pay for the first 4 weeks. The last 1.6 weeks can be paid at the basic rate only. When you look at somebody that works irregular hours, part year, then you're not differentiating. They must get their normal rate of pay in accordance with that definition I've just shown a moment ago. regardless of whether it's the first 4 weeks or the last 1.6 weeks. So there you've got a discrepancy, but it's in the regulations. Again, I don't know the logic or the reasoning for that. Again, it could be something to do with the fact that they're overturning that Harper Trust ruling. But the thing to know is that's the statutory provision, but actually probably in reality, most employers are probably just paying one rate of pay for the entire 5.6 weeks because of the administrative burden it places on employers to manage both a normal rate and a basic rate, as you can see here for regular hour workers. But I just wanted to highlight the statutory position on the holiday pay and how it can differ depending on the type of hours the person works. So when you pay holiday pay, again for irregular hours part-year workers, there are now two methods that can be used. You can either use your 52-week reference period, which is what we've always had because it's in the Employment Rights Act, or you can use a new method of rolled up holiday pay, which I'll come on to. If you use a 52-week relevant period, it's not the same as the 52-week reference period I've just explained when you calculate entitlement. There are important differences. You must calculate average normal pay based on their actual earnings from the last 52 weeks, but only in weeks where they've worked and earned pay. The relevant period begins from the day before the employees start their leave and goes back to 52 weeks. And the important difference between this 52-week period to the other one that I've just gone through is you not only exclude weeks where they've been on maternity, family and sick leave for any amount of time, you must also exclude weeks that have not been worked for other reasons. So this is a crucial difference. So there are two separate 52-week periods. So this one for pay, you only look for weeks where they've worked and earned pay. And again, there's a cap, which is your 104 weeks to go far back. And employees that have started in the year, then you go back as their start date. So I appreciate there's a lot to process. It is complicated. We've actually created a lot of guides and toolkits and calculators to help because it's such a complicated area. The rolled up holiday pay is new. In previous years it was allowed, then it was made unlawful, now it's lawful again. It can only be used for holiday years that start on or after the 1st of April. And again, it's only for those that work irregular hours or part year. But it allows you to pay an additional amount in each pay period to cover a worker's holiday pay. It's instead of paying holiday at the time it's taken. So, for example, then, where holiday is allowed to be carried over, because you're paying holiday pay on a monthly basis, there's no further payment that's made to any holiday that's being carried over because they will have already received it in the holiday year that it was due. And the other thing to be mindful of is when people leave employment, there'll be no need to make a deduction of pay in their final payment to address any overpayment because, as I said, you've been paying their holiday pay as you go. So they've been paid regularly throughout the year. So there are a couple of things to consider when you're generally managing rolled up holiday pay. What I would say is if you're looking to introduce it, it is likely to constitute a variation of the terms and conditions of employment, and therefore engaging with your workforce, consulting with them about the change, talking about how it may impact them, and then it's about implementing it in line with their contracts. It's not just something you can just bring in overnight. So I think now's a good opportunity, Sue, to see if there's any questions.
We've had a few, especially since we moved on to holiday pay, as you might expect.
Yeah, my favourite topic.
It's a hot topic everywhere, I think. So some of them may have been answered, but we'll just clarify in case with the subsequent slides. So the first one is the holiday carryover rules. It's an interesting one, this, particularly in the social care sector. There is a challenge with using holidays in the holiday year. She says, do the COVID rules apply still when you can't take holiday due to business needs?
They end 31st of March.
this year, isn't it?
Yeah,
Yeah.
yeah.
So it'll be up. You won't be able to carry forward your
No.
statutory holiday, but you can carry forward any
Yeah,
holiday in addition, can't you?
the COVID ones were specific, obviously, in response to that emergency, and people were given, I think, a couple of years, weren't they, to be able to carry over, but that now ends 31st of March. It's a good question.
Yeah, absolutely. So the other question is, if an employee is full-time with regular hours,
Full-time,
would the
regular hours.
full-time regular, yeah, would holiday pay be their normal pay? I.e.,
Yeah.
if they are on holiday or not, they receive the same pay, which is
Yeah.
straightforward.
Yeah.
I think that came in just before you did the slide on pay.
Yeah.
So the next one is to do with bank and casual staff who only work when required.
Yeah.
Same as irregular hours workers. Some may work consistently to cover vacancies. Others may not work for months. So are those bank casual staff who work consistently to cover vacancies the same as irregular hours workers?
So it's hard without actually seeing somebody's work pattern and history of hours worked. If so there's almost like, I've used this phrase before, they're irregular hours.
Yes.
In that they're providing work in most weeks, it's just there's no regularity to the hours in which they've worked. I don't know if I can go back to that definition slide, but essentially it all will come down to whether they meet the, let me see if I can get to the definition again here, just bear with me. So I think if the number of paid hours that they will work in each pay period during the term of their contract in that year is under the terms of the contract wholly or mostly variable. So it's how we interpret that, isn't it, in the circumstances, and that's why it's hard without knowing that person's
actual working pattern, isn't it?
History,
the reality. Yeah. So it would need a bit more. As I can see, that query came from a client. Do contact us and talk to us about it, and we'll work it through with you.
Definitely.
It just shows that how hard it is sometimes to decide which category they come in, because it's quite significant what you can and can't do in terms of treating their holiday entitlement as well as pay. So this is another one about the 12.07% for irregular hour holiday calculations. Is there a cap? For example, the statutory entitlement to 12.07% or hours up to 28 days.
So,
but the 12.07% is calculated based on the 28-day entitlement, isn't it? So
so the only cap we have is that, say somebody works 6 days, sorry, they still only get 28 days.
28 days, yeah.
That's where there is a cap with holiday rules. So it doesn't matter whether you work 5, 6, 7 days, you're still only getting 28. That's the only cap.
Yeah. The holiday calculated using the last 52 weeks. If they get paid monthly, can we use the last 12 months?
Are you talking about entitlement or pay? Entitlement, are we?
Holiday calculated, I would say holiday entitlement.
When you work out entitlement, so if they're paid monthly, they work monthly.
Yeah.
When somebody's had a period of, so the 52-week period, when you're working out entitlement, applies when they've had a period of, say, maternity leave, because you need to know how much they've accrued in each week of their maternity leave. So that's where the 52 weeks comes in. If they're not on a period of family leave or sick leave, you look at how many hours they've worked in their pay period. So they're paid monthly in this case. So you look at those hours worked, and then you just use your 12.7 on those hours.
Yeah. Okay, thank you. And somebody has to say they have an annual allowance of 27 days plus bank holidays for full-time employees and allow a generous carryover of 15 days. Should this be reduced down? So 27 plus bank holidays plus, say, 8,
34,
35
35
days,
days.
and they've got 15, so there's 20 days. So they're all right as long as
Yeah.
20 days are taken in the year. So yeah, you can do that. It's still only the 20 days, isn't it, that you can't carry forward?
Yeah, and I think so. The rules that I've gone through earlier are relating to the statutory provisions. Employees are entitled to write their own rules about enhanced benefits they give. So how you want to manage the enhanced element you offer, that's down to your business in terms of
Yeah,
carryover and things.
yeah.
Yeah, I think I'm
And
saying
then if
what you're saying.
yes, quite. And then actually, if people are paid quarterly bonuses, does holiday pay have to increase if they are regular hours workers?
Regular hour workers,
So the
bonus payments. So
bonus is in normal pay, isn't it?
yeah,
Regular hours workers. Yeah,
if it's a regular payment, the case rulings up to now have all been about how you include it in your
yeah,
calculations. For the purpose of these slides here and the definition that we now have, that is when we're talking about irregular hours and part-year workers. But regular hour workers still have um, additional pay included if it's regular.
yeah.
A lot to get your head around.
It is a lot. It is, and in fact, the last question in this section is calculating the 12.07% if they get more than statutory
Yeah,
leave. I think we will send you our toolkit because
yeah,
one of them is how to do that to calculate
yeah,
it, or when you offer more than statutory, and that should help. So
yeah.
that will
I'll
be
send that
winging
out
its
to
way
everyone.
to you, that
Yeah.
one. So yeah, I think that's all for this section.
Thank
Thank
you.
you.
Really good questions. Um, Now to the easier things that's changing. And so the next piece is about the paternity leave, because they're changing the way in which it can be managed. So what we're going to be seeing is where there is an expected week of confinement that is after the 6th of April, or where there's the expected date of placement or entry to the UK when we're dealing with adoptions is on or after the 6th of April, then the employee can take their paternity leave in a more flexible way. So they can take it as either 1 week, they can take it as one block of 2 consecutive weeks, which is the case now and always has been. The change is the fact that they can take 2 1-week blocks throughout a 52-week period. So that's where the flexibility comes in. They can now take 2 lots of 1 weeks at different times. So the notice of entitlement remains the case in that they have to notify you of their entitlement, their eligibility before the 15th or on or before the 15th week before the EWC or 7 days of adoption. But when it comes to then managing each period of leave, the notice then is being reduced to 28 days. And as I said, it can be taken at any time in the 52 weeks after the child's adoption or birth. So as I said, that's one of the more straightforward ones, and it's all about the flexibility and how it is managed for the employee. And then carers leave, you will have read and heard about this in the news. It's a big topic of conversation. You know, we are all having increasing needs to provide care for family members, and this just mirrors the need of society. So we have a commencement date of the 6th of April. All employees will be entitled from day one of employment to take up to 1 week of unpaid time off to provide or arrange care for a dependent who has a long-term care need. And then from a legal protection point of view, employees cannot be penalised for taking advantage of carers' leave entitlement, and any dismissal connected to the taking of it will be automatically unfair, i.e. you don't need your qualifying 2-year service to lodge a claim. So within the regulations, we have clear definitions. So a dependent, this is probably easy to sort of get your head around because it's the same definition of when you're managing time off for dependence leave. So it's somebody's spouse, civil partner, their child, their parent, somebody that lives in the same household with a few exclusions, or any person who reasonably relies on the employee for care. That's a catch-all provision. The regulations also define actually what long-term care is, and it says that the dependent will have an illness or injury, and that could be physical or mental, that requires or is likely to require care for more than 3 months, that person has a disability for the purpose of the Equality Act of 2010, or they require care for a reason connected with their old age. So they're the factors that will determine whether somebody is eligible for that leave or not. And as I said, that's coming in from the 6th of April. In terms of the approach to managing it, there are the regulations stipulate a few things. So, for example, the notice period that somebody gives you must be in full days. Carers leave can be taken in 1 day or less, or for requests of 1 day or less, they need to give you the notice of 3 days. For requests of more than 1 day, the required notice is at least twice as long as the requested leave. Importantly, employers cannot require evidence of the care need, nor can they refuse a request. However, as we can with similar entitlements, employers can require that it's postponed, but only if it would cause a serious disruption to the business. And if that was to be the case, then legally you'll be required to provide a written counter notice within 7 days of the request. It's got to be in writing. You've also got to set out in writing the reason for the postponement and set out a new date within 1 month of the original requested date. So there's certain legal obligations on your part that you have to conform with. And then in terms of practical steps, you're going to need record keeping systems to track the leave taken and remaining entitlement, and create a policy and supporting templates, and have the associated self-certification forms, and importantly, line management training. Now, with regards to the entitlement of up to 1 week, clearly that's prorated. So if somebody works regular part-time hours, so for example, they work 3 days a week, their carers leave entitlement would be 3 days because that's their week. If somebody works irregular hours, then that's where there's a 52-week reference period that's used to understand how many what hours of entitlement they are entitled to. So there are certain obligations for employees in regards to requesting carers leave. So got a couple of quick polls just to get your thoughts and see how this may impact on your business.
Okay, so I'll launch the first one. So it's really to understand how much of an impact this might have. We've had quite a lot of requests for a carers leave policy over the last few months, actually. So a lot of people have gone early with it, and brought it in before the April date.
Yeah. And some employers may enhance it. So the statutory provision is unpaid, but actually some employers might choose to allow pay.
Choosing to pay, yeah, they are. Okay, I'm just going to close and share that. So we have significant impact, really, because 62% is more than 25%.
Yeah.
Yeah.
So and that doesn't surprise me, actually.
So I'll ask the next question, which is to do with the holiday pay, actually, implication. So this is, are you likely to consider introducing rolled up holiday pay, having not been able to do it for so long? Now we can. I think
It's
some
back
people
and
had only
forth.
recently actually removed it when it was finally made illegal,
Yeah,
officially illegal. And are you
it's
going to bring it
probably a
back?
much more straightforward approach than the 52. But
Yeah,
having said that, there's a lot of work to go into it before implementing it.
yeah. So there we go.
Yeah,
Either no or not sure. Yeah, it's quite a turnaround, isn't it, on of
it
events,
is.
considering we had some clients we've been working with to remove it, and it's taken them quite a long time because of the having to give notice of the
Mm,
changes and everything, go through the consultation, and then they removed it last year.
yeah, and I think what's hard is as I said, the approach to introducing it, and
Mm,
how can you be sure that by introducing it, somebody isn't going to be suffering a detriment?
detriment, yeah, and that's the
Because
challenge, isn't it?
you can't really
Mm,
compare like for like. So I think it's really challenging, and it's trying to understand what would they get under the current system versus what could they get if you applied the new system.
mm.
Um, but that for me is an area of complication.
Yes. Okay, I think that's all at this stage,
Yeah.
isn't it?
Okay. Oh, thank you for that. Really interesting. So, going to move on to employment protections for maternity leave, adoption leave, shared parental leave, specifically to do with those who are in a redundancy situation. So, as you know, the current protection is for any employee that's on your adoption, maternity leave, shared parental leave. They have that legal protection that if they're made redundant, then they must be given a suitable alternative role in preference to other employees. The protection exists whilst they're on leave, but it ends as soon as they come back. We're now seeing changes to that. So not only are we going to see it broadened and extended, but timeframes changed. So from April 2024, and I'll come on to specific dates in the next slide, the length of period that somebody will be protected will change, will get longer. The protection is also going to include those who are pregnant, and it will also apply to anyone should they suffer a miscarriage or stillbirth. And this hopefully summarises it in a succinct, clear way. So somebody that's taking adoption leave, then the protection begins when adoption leave begins. So 18, and it lasts for 18 months. It runs until 18 months from the date of placement in the UK, or 18 months from the date of entry into Great Britain if it's an overseas adoption. When you have a pregnant worker who is then going to take a period of maternity leave, so it starts when the employer is notified of the pregnancy, so right early doors, and then it runs through, it ends 18 months from the child's date of birth when the employer has been notified before the end of maternity leave. If not, then it ends 18 months from the EWC if they haven't been notified. So it's this 18-month duration. For those employees who are pregnant but unfortunately suffer miscarriage, then it starts where the employer is notified of the pregnancy again, depending on the scenario. So if somebody was to have the miscarriage, then it ends 2 weeks after the miscarriage, when that happens before the 24th week of pregnancy. And then if somebody was to suffer a loss or stillbirth and it's after the 24 weeks, then it's the maternity rules for pregnancies for the maternity leave. So, so as it stands now, if somebody loses a baby after the 24 weeks, they're still entitled to the statutory maternity leave and pay. So in this scenario, the protection continues to extend until 18 months from the child's, what would have been the child's notified of the stillbirth or EWC. For those who take shared parental leave, then, and they've not already taken adoption or maternity leave, then it begins when the shared parental leave starts. and it ends at the end of the shared parental leave when less than 6 weeks have been taken, or it ends 18 months from the child's date of birth when more than 6 weeks consecutively have been taken due to shared parental leave. I think all I'd say is, because there's so many date scenarios, I think it's one of those that as and when you get a scenario come up, just remind yourself of that summary table. If you're contemplating redundancies, then you need to be mindful of this, because obviously this comes into effect very, very soon. Okay, flexible working regulations. I don't quite know where to begin with this, because all we know at this point is the regulations have been signed off in part, but we're waiting the other part to be confirmed. So all we know at this point is that it's a day one right from the 6th of April. Applications received on or after 6th of April. The other regulations are still in draft format, and it's those regulations that set out all the other details that are going to be coming in. We're working on the premise that they're all going to come in from the 6th of April, because when you read the draft ACAS codes of practices, when you read the government website, it's all geared up to the 6th of April. The only thing, as I said, that's conflicting with that is we just haven't had the confirmation. We're now the 28th of March, we've got Easter, and it's really difficult to manage. So the applications received on or after the 6th of April, as I said a moment ago, employees don't need any length of service to qualify, they can put a request in. We know that other changes to the statutory rules are pending. We are still waiting for that, we're monitoring it. As I said, we've got conflicting information between the ACAS Code of Practice, the regulations, but we think it's likely to be April, because it would seem odd for them to be brought in separately. At this point, we can only advise that you have 2 policies that are ready to go come the 6th of April. One policy that has it as a day one right only, and then the other policy showing all the changes. But in terms of all those other changes, I'm just going to take you through what they are. So first of all, employees will be able to make 2 requests in a year, which is an increase, and requests must be dealt within 2 months of receipt of a request, assuming there's no extension requested. So at the moment, it's a 3-month period in which to deal with it from start to finish. Now it's going to be reduced to 2. Employers will be required to consult with employees before refusing a request. And the new right to request flexible working applies to all employees, those who are on fixed term contracts, 0 hours contracts, agency contracts. The regulations will no longer require employees to set out in their application the impact of the proposed new working arrangements and how it will be dealt with. So that's a summary of the changes. As I said, it's a little bit difficult because we're still waiting news. And as soon as we do, we'll be sharing it all on our website, knowledge base. And obviously, if you're a client of ours, we'll be engaging with you closely on this. So Sue, probably now is a good time to check in with any questions.
Yep, we had a few more.
Okay.
So the first couple are to do with carers leave, and one is just for clarification. The 1 week's entitlement, yes, it is every 12 months.
Yes.
You can take 1 week carers leave.
In a 12-month period, yeah.
In a 12-month period, yeah. For the carers leave, can an employee take both carers leave and ordinary parental leave? I think my response to that would be, as long as you fulfill the eligibility conditions for each of them, there's no reason why you can't take both. Although parental leave is predominantly looking after a child's welfare, and the carers leave is quite specific in the eligibility for the type of care that is providing, such as the physical and mental illness or injury, a disability, or care needs because of old age. So it could be
it could fall in the
both.
definition.
Absolutely. Yeah. So yeah, if you're eligible, then yes, I don't see why not. Somebody had commented that with the notice requirements for carers leave, the refusal could be after they've taken leave in some cases. So how do they handle that? I think you wouldn't be able to really, unless you can reasonably refuse when they give you notice. and you've got a genuine business need,
Gosh, this is tricky.
yeah,
So
they have to give you notice. So
yeah, the employee has to give you notice to get their
yeah,
statutory entitlement. If they're falling foul of the
a
statutory
notice
rules,
requirement, then yeah,
yeah, then
then
you're
that's
entitled to
Revocation.
manage that as you see fit in line with your
Yeah,
policies.
but yeah, because if they've fallen in line with the notice requirement, then you have
Mm,
to refuse it in that notice requirement. So before they take the leave, and you have to have a serious business need to be able to refuse it, just because you
yeah,
can't actually even ask why they need it. And then this leads on to the next one, which is sometimes managers think that staff take carers leave because they've used holiday or are on absence management procedures. Can there be too much carers leave? Well, it is restricted to a week and it's unpaid. So
and it's quite specific again with the
yeah,
definition of
the
who
definition.
qualifies and
Yeah,
eligibility. You know, about the health circumstances of the dependent that you need to support.
yeah. And then a really interesting one with this flexible working. So if an employee asks for flexible working from day one for childcare, can we still refuse it as it will affect performance and client contact? It's down to all
It's
the
only,
reasons for refusing,
yeah,
isn't it,
I
for
mean,
flexible working?
it's reminding people that it's the right to ask, it's not the right to
Yeah,
have. That's
yeah,
probably a clear message for employees, isn't it? And you're
yeah.
entitled, if you can justify it, falls in within one of the statutory reasons, you
To
certainly can.
refuse, yeah.
Yeah,
And but no longer does the employee have to justify or explain how the employer can cover those arrangements. It's up to the employer to respond what their business
yeah,
case is, turning it down. And the assumption is you will be able to accommodate it, and so you have to then say why you can't.
yeah,
So it is going to be challenging
exactly.
for a lot of
Yeah,
people.
that's
Yeah,
exactly that, because when you read the code of practice, albeit it's draft, it does provide a sense of the starting point is you're accommodating it, and then it's working through that, and then as you're working through it, when your practical challenges come up, you're identifying them, and then that's where you're getting to the view that actually no, we can't. So it's almost the code is encouraging employees to take it, to swap it round, the mindset round, about your starting point that it's working, and then work through it, and then working out that, as you know, we can't, and we can't for these reasons.
yeah, absolutely. And then again with flexible working, if offices are only open certain hours, is that grounds to be able to refuse? Potentially, but the reasons might not be just because the hours of that. It might be around lone working and all the other considerations you need to consider, and or if you do allow working overtime, or if it has to be in the premises, or so that there's a
Yeah.
lot of ifs and
Yeah.
what ifs. So you can't just turn it down because the office hours are this.
Mm.
It may be that it's the impact on service if you don't require the service outside those hours. But you'd have to explore it in
It's
detail,
hard,
wouldn't
isn't
you?
it? And all the
Mm,
whole communication piece, how can you stay engaged with your employer if you're working completely different to when the office is
yeah,
operating, things like that. There's a whole lot of things to consider. Mm.
absolutely. And again with flexible working, how long does a flexible working agreement last? It's a permanent change to terms and
Yeah.
conditions, and you can't revert unless you introduce a trial period as part of. If you're not quite sure if it's going to work on either side, either party, you can agree a trial period, and if you have good reason during the trial period to say it's not working, then
Mm.
they would revert to their original working pattern. But if once you've agreed a flexible working arrangement, it's a permanent change to terms and conditions, and
Yeah.
you expressly confirm that in the response.
Yeah. Although
And
they
they
can
can
put
submit another
requests
one,
in.
yes. So yeah, you
But yeah,
can submit another request, two requests under the new rules when they come in. So yeah.
you know, I suppose it's interesting that, because you can genuinely have a situation where, I don't know, a big life event takes place for you, and and you need to look at your hours again. So it's not unusual, I guess, for somebody to need to look at their hours twice in a 12-month period. But it seems, yeah, interesting, isn't it?
Mm. And then there's a question around the trial period is what is regarded as a reasonable trial period for a flexible
Oh,
working request? And that depends on the
gosh.
request. You need
Mm,
to think what is a reasonable period to assess whatever it is that's in question. So it could be that the particular days and hours of work are you feel might be detrimental to delivering the service, but you need to test that out. Now you might
mm,
be able to assess that if you're a really busy department in a 2 3 weeks, but in some situations you might need to assess it over a longer period to be able to make that judgment and it be considered a fair and reasonable judgment. So it is very much. I wouldn't have thought too long would be fair,
mm.
unless there's a justifiable reason for it, or
It,
something that
yeah,
doesn't happen that often that you need to assess.
it's
But there isn't a cap, which
no,
is the subsequent question.
and it's long enough for you to be able to retrieve evidence to back up your decision whether you're going to continue or whether you're not, and make that decision, isn't it?
Yes, yeah. Then this is generating quite a few questions. If you agree a flexible request and then you see an impact on performance, what can employers do?
Interesting.
That is an interesting one, and really that's why you need, if you have any doubt, you need to assess the impact, consider the impact beforehand. If it wasn't conceived, then you'd be into either arranging additional cover or speaking to them again and saying, actually, we could do with more hours or different hours now, the business needs have changed. But that's like it would with anybody, not just because of the flexible working. You couldn't treat them differently because they'd submitted a flexible working request. So it would be like any working arrangement.
Yeah,
You would have to talk it through and see if you can agree on a change. I think we'll leave it there, and then
yeah.
we'll ask some more questions in the next slot, if that's okay.
Okay, yeah,
Yep.
perfect. Thank you. Actually, we've got a poll.
Oh,
Incoming,
yes.
incoming. Two quick questions here.
Okay, I'll launch the first one.
I think they're just to follow up on these last few slides.
Yeah, okay, I'll share that. And so,
Okay.
still quite a number are. It's good to see that not many of you are,
Yeah,
but there's still quite a few that are. And now the next question is linked with this, I think, isn't it? Oh, it's about flexible working.
yeah.
Yes, that's right. Do you already offer it from day one of employment?
It's just useful to see what other employers do.
Mm.
Because I know there's been a lot of research showing how flexible working, hybrid working actually has a positive impact on retention, the ability to recruit.
Yeah, yeah.
So quite a few employers have already had day one for a while. So yeah, 35%.
Already offer it. Yeah, that's amazing. Yeah,
So from next week, oh, 6th of April, sorry. When
yeah,
is the 6th of April? Just over a week after next, isn't it?
yeah.
Okay, so
Okay, so
thank you.
back over to you.
And really this next bit is to go through other changes that are happening that are more on the horizon. So we've got a bit more time to think about how they impact on us. I guess the first one is the Employment Allocation of Tips Act 2023. This, I guess the purpose of these regulations really is to ensure that there's the fairness and transparency in how tips and gratuities even are allocated. the new rules are going to come in. It's a big change, I think, for hospitality. It's going to apply to all workers, but not the self-employed. And there is a draft code of practice available already on the fair and transparent distribution of tips. We are currently awaiting the government's response to both this draft and a recent public consultation, but we are expecting the changes to come in from July. What the obligations will be for employers is to pass on all tips and service charges without deductions. There'll be exceptional circumstances where that can happen, such as deduction of income tax, but essentially they must be passed on in full. The tips must be distributed in a fair and transparent manner, where the employer takes control or exerts significant influence over their distribution. It will place an obligation on employers to have regard to the new code of practice that's available on how they distribute the tips, and there will now be a requirement to maintain a written policy on how tips are dealt with at the place of business, and that policy is made available to all workers. It will also mean that employers have to maintain a record of all tips paid at their place of business and their allocation and distribution between each worker, because the new rules, the new laws will allow workers the right to request access. So it's about ensuring that the total amount of qualifying tips is allocated fairly, and that includes where there's a mixture of your permanent staff, those that you've recruited directly, those you recruit through agency workers, 0-hour workers, you know, everyone that's in the same location, they are all included and should have the tips allocated fairly. But the allocating and distribution of tips doesn't necessarily mean that workers are allocated the same proportion. There could be very legitimate reasons why different proportions are allocated to different workers. But as with anything from a HR perspective, you've got to have those clear and objective factors when determining a policy. So when you determine the allocation and distribution of tips, because you can't have any system that is discriminatory in any way. But as an employer, you're able to determine the factors, as I said, so long as they're fair, reasonable in the circumstances and in the context of the business. Now, the code of practice, albeit still draft, does provide some examples of what may be considered when you're determining the proportion of tips. And it could be somebody's role type, it could be basic pay and how workers are engaged, individual team performance, seniority, levels of responsibility, length of service with the organisation, or even the customer's intention. So there are some examples in the code that helps, and it's really finding what's appropriate for your business in the context of what you operate within. The regulations do require employees to consult with workers to seek broad agreement that the systems that you have in place for allocating the tips is fair, it's reasonable and clear to everyone. The factors considered by the business for allocating and distributing tips must be specified in the written policy, and you need to give consideration to whether there are any contractual obligations to engage in formal collective consultation where a system affects the terms and conditions on pay, or if you've got an existing collective agreement, you know, you've got to ensure that you're consulting in line with those working practices. So there's various methods how employers can allocate and distribute tips. So the employer receives directly and pays their workers in the next payroll cycle. You could allocate an internal resource for being responsible for operating independently a trunk, or appointing an external independent trunk operator, although the employer, you will be responsible for taking action to address any concerns where a third party is acting in an unfair or improper manner. And when it comes to the allocation of tips, these must be distributed at the latest by the end of the month, following the month in which they were paid by the customer. Now, I mentioned a moment ago, employees will have a legal right to request details of how they're allocated. So record keeping is going to be fundamental. So you need to keep clear records. You need to include details of all the qualifying tips that you've received and the amounts that have been allocated. And you've got to maintain those for 3 years, beginning with the date on which the tip was paid. So the workers will actually have the right to make one written request in a rolling 3-month period in order to view their tipping record of the employer. And it can go back up to 3 years, so long as they've worked for the employer for the full 3 years. In terms of tips and gratuities, then if individual workers are not aware of their entitlements, an employer cannot be deemed to have met its legal obligation to handle tips fairly and transparently. So it really, really is important that you communicate clearly the policy, how people can access it. But actually, if you're using agency workers as well, they also get that same information. Because if it's found that they are not aware of their entitlements, then a tribunal will deem that you've not met your legal obligations. All staff should have the same access, as I said, to the written policy, must be in plain language and provided in accessible format for any worker with a disability on request. And employers can provide a copy to the agency workers at the start of the engagement, or you can ask the agency to share the policy on your behalf. You don't have to share the written policy with customers or display publicly, but you may do so if you wish. So moving on to the dismissal and re-engagement, this all came about, this employment bill was introduced on the back of the P&O Ferries case, where they dismissed around 800 people on the spot. No consultation, no fair redundancy process. So a bill went through Parliament and has been consulted on, and there's a code of practice that's going to be launched. So the purpose of the code is to ensure that all employers take all reasonable steps to explore alternatives to dismissal and to engage in meaningful consultation. So meaningful is a legal technical word. It's about how can you ensure that you're being consulted on meaningfully. So have you had the opportunity to participate in that consultation? Have you had all the information to be able to ask the right questions, etc.? There's many, many different factors that can qualify what we mean by meaningful. And then it's about ensuring that the employer doesn't raise the prospect of dismissal unreasonably early or put undue pressure on employees by threatening dismissal where actually it's not envisaged. So it's just, I think, pretty much we're probably already managing dismissals or re-engagements in a fair way. I think the code of practice is just trying to make things a bit more clearer and to prevent further issues like the P&O Ferries happening again. The draft was published in February, but the date of commencement is to be confirmed, and it's going to apply to all employees regardless of size. And it will apply when you want to make changes to your employees' contracts of employment, and where agreement cannot be gained, then it's about when you dismiss and re-engage on new terms or engage new employees to perform the role. It is going to be a legally binding code of practice, so that means, as we have with other codes of practice, your tribunal can increase awards by up to 25% where an employer has unreasonably failed to comply. But equally, employees may also have their awards reduced by up to 25% if they also unreasonably fail to comply. So the Worker Protection Amendment of Equality Act 2010, this is about extending existing protections to against sexual harassment. So it comes into force on the 26th of October, and it's about enhancing existing harassment protection and placing increased responsibility on employers. It's basically going to be updating the definition of harassment, but for the purpose of the Equality Act only. You may be familiar or know that harassment claims can actually also be made through the civil courts, because we have a separate piece of legislation known as the Protection from Harassment Act of 1997. But the purpose of this duty, this falls within, excuse me, the Equality Act of 2010 and the definition. But what will it mean? Well, it's going to be putting a specific duty on employers to take those reasonable steps to prevent sexual harassment of employees. Any compensation for harassment of a sexual nature can be increased of up to 25% for failing to fulfil the new duty. And the Equality and Human Rights Commission can use existing powers of enforcement. So I think, you know, you'll all have policies and procedures in place around diversity, equality, bullying and harassment, that will already set your stance on how you prevent harassment, bullying, etc. in the workplace. So the new duties, it's just going to mean employers make sure that their systems are comprehensive enough and the practices are really watertight in preventing sexual harassment. So we would advise auditing your existing systems and working practices now to help you prepare for October. It's really important to understand if the business is proactively establishing measures that can be deemed as reasonable steps in preventing sexual harassment, because that's what the obligation will be in the eyes of a tribunal. Have you taken reasonable steps? So those measures will include having the regular training, having clear, comprehensive policies and procedures, but also reviewing the effectiveness of your policies and procedures. You know, it's no good just having a written policy and then just not monitoring its effectiveness. You've really got to see that actually, are we tackling this particular issue in the workplace? It's about having a positive workplace culture that encourages people to speak up. Think about how you plan events. You need to plan carefully to put to mitigate any specific risks, and carry out regular risk audits of your organisation. So these are all things that you probably already have in place and are already doing, but just I think it's really vital that you sense check you are doing it comprehensively enough and you're following up on things. So even things like, if you were to get a disciplinary matter grievance case, look at what learnings have you had from a case. Do you need to make tweaks to anything to prevent something from happening again? So I think now's a good time to do an audit of your working practices to see what you need to tighten up on, ready for October. And then here we've got the workers' predictable terms and conditions, which is a really interesting piece. It's expected that to come in from September onwards. We're waiting confirmation, but what it will do is give workers a statutory right to request more predictable terms and conditions of work where there is a lack of predictability. Now, the regulations we've got are in draft format, and they actually define what a work pattern is for the purpose of putting a request in. So it's something about somebody's number of hours that they work. It could be to do with the days of the week worked and the times on those days that they work, or it could be the period for which the worker is contracted to work. Interestingly, in the regulations, it talks about fixed term contracts. So we saw in the poll earlier that many of you do use fixed term contracts. So where there's a fixed term contract that's less than 12 months, the regulations specifically deem that to be a work pattern that's regarded as having a lack of predictability, and therefore it means it falls in scope of the draft regulations, and therefore somebody can ask for more predictability. So in terms of applying predictable terms and conditions in the context of a fixed term worker, the contract, they could request a change to the duration where it would therefore result in a longer fixed term contract, or they could request the removal of a provision that's restricting its duration. So I think it's quite interesting development that on fixed term contracts, because essentially any under 12 months will fall within scope of these draft regulations. So an employer will be required to deal with the application in a reasonable manner and within 1 month beginning with the date on which it's made. And I think the easiest way to get your head around it is it's very similar to the flexible working process. So there are only certain statutory reasons why you can reject a request for predictable terms, and they're the same ones as your flexi ones. So your burden of additional costs, whether it has a detrimental effect on the ability to meet customer demands, etc. So the framework for managing it will be very similar to your flexi, but it's about people asking for more predictable terms and conditions. And then really neonatal leave is probably one for 2025, but I've just captured it for today's seminar, and we might even have talked about it in last year's seminar because it has been on the horizon for some time, but it is expected from next year and to be a day one right. Neonatal care, as drafted in the employment bill and the draft regulations, is the type of care that a baby receives in a neonatal unit. So if they're born premature, or if they're sick, or with a low birth weight, and it can also include those circumstances where the child needs medical or palliative care. There is obviously eligibility criteria, as we see here. So a parent of a baby or babies that are admitted into hospital as a neonate, the admission has to last for a continuous period of 7 days, and the entitlement will apply to someone with parental or other personal relationships with a child that is receiving the care. And we're expecting the total amount of leave to be capped at 12 weeks. Now, this isn't all definite. This is what we're expecting. Obviously, things could be refined. And in terms of taking the leave, then they're talking about it being taken in a continuous block of 1 week or more weeks. The notice requirements, understandably, are likely to be very short, but obviously depend on the circumstances. We expect the maximum notice being asked for is a week. Where there's evidence, employers may require evidence, and they may be able to ask for a written declaration from the employee. And when it comes to employment protections and rights, they'll be afforded the same as other forms of family leave. So, for example, they'll be protected from suffering a detriment for having exercised a statutory right, protection from discrimination, etc., the right to return to the same job. So that's, as I said, due to come in 2025. Now it's 11:36 and we are coming to a close, but I thought before I do, I'm just going to highlight just some significant case rulings that we've seen, and actually full details are going to be provided in the email that goes out afterwards, but they're all really interesting. In the first case in particular, Linsky versus Direct Line, is a good reminder of how the Equality Act works, and in particular in the context of someone going through the menopause. So it's a case where the employee was subjected to a performance management process. She felt that her menopausal symptoms that she was experiencing were actually contributing to her underperformance. The employer gave her formal sanctions for her performance, despite her saying that her health concerns were contributing it, those health concerns being menopause. She went off sick with stress and then eventually resigned. So it is an interesting case. She won her case and it found that the menopause symptoms were actually considered a disability for the purpose of the Equality Act. The second case that I've highlighted here is really about employment references. We don't see too many, but this was actually kind of interesting as a reminder about the importance of issuing accurate references. So it's a reminder, first of all, that we don't have a legal obligation in the first place to provide an employment reference. There are certain sectors where it is more important and necessary, but when a reference is provided, then this case has reinforced that they must be factually correct, deliberately correct, leading or malicious. It is a case that went to the High Court for claims of libel, misuse of private information and negligent mistreatment. And whilst the majority of our time as HR practitioners deal with claims at employment tribunals, such as discrimination, unfair, I think this is just a good reminder that other claims can arise from our employment practices as well. So this is a case where the High Court did rule that a hypothetical reader would have taken the reference at face value, and therefore the words that had been used implied the individuals had done something wrong, and therefore they were found to be defamatory. Holiday pay is another key area. We've talked about a lot about holiday today, but just briefly, in this case, you may have heard about it because it's been going on for years. It's the Chief Constable of Police Service of Northern Ireland, v Agnew, and it is complex. Initially, it dealt with whether they were employees or workers, so employment status. Eventually, after many years of through the courts, they deemed that they were employees for the purpose then of calculating holiday pay. What had happened is that they had their holiday pay paid at basic rate and not include overtime. And so that was the first hurdle they sort of lost. Once that ruling came through, then the question came up about breaks in the payment, because in this situation, it's about whether there was a gap of more than 3 months and whether there could still be claims of unlawful deduction of wages. What we had was the Supreme Court ruled that the aim of the legislation was to protect workers against exploitation. And so they deemed that the claims brought and added that when considering whether the deductions from a series, all relevant facts must be considered. So basically, it should be remembered that whilst in England we have the Employment Rights Act that limits claims for backdated holiday pay for 2 years, because this was a Northern Ireland case and they have other legislation, they don't in their regulations have that 2-year limit, and so there's a risk of liability for claims dating back to when the working time regulations came into force, which is way back in 1998. So from a general risk point of view, then I think for those operating in England and Scotland and Wales, then we've got that 2-year backdated period that we can go to. And I think for many years, because of case rulings have indicated to include overtime, many employees have been doing that correctly. So probably the risk is not as significant, but certainly for operating in Northern Ireland, where there's not this 2-year claim period, that is certainly a challenge. And then just in terms of the employment status, HMRC versus game match officials, this is all about is somebody a worker or employee, and in particular focuses on the concepts of mutuality of obligation and control. And the Court of Appeal held that the workers were in fact employees, but it has now been taken to the Supreme Court ruling. So actually we're waiting for the Supreme Court to give their judgment. So that will be something to look out for later this year. So full details and descriptions of those cases will follow, but I just wanted to highlight those as part of today's session. And really, just before we get to taking some more of your questions, I think we may have some more polls, really just to run through what we would recommend your 7 key steps are for preparing with all these changes. First of all, definitely recommend audit your HR practices, because you need to understand what needs changing to comply with all of these changes. Once you've done your general audit, you can also then think about strategic planning for the year ahead, whether there needs to be a focus on line management training because of all these new developments. Then it's about gaining leadership buy-in, because once you've got your strategic plan, you need to get the buy-in from the top and have their agreement to proceeding. And informing and engaging your workforce is critical. So how you inform them of the changes to the new employment developments, their new employment rights. If you've got obligations to consult, then make sure you follow those to the letter. And also then update your employee documentation. whether it's that will include your handbook, your contracts, your policies, your template letters, forms, everything. And then it's really fundamental that your line managers are trained, because ultimately they're responsible for managing your people and working in line with the law. And then, as with anything, it's about monitoring the effectiveness of your policies, your contracts, all the changes that you've introduced, and review and make tweaks as you see necessary moving forward. So that's a summary of the 7 steps really to prepare your business. And I wanted to just sort of bring the seminar to a close with a final poll around what do you think is going to be the most have the most impact on your business this year. So it's going to be in 2 parts, I believe, Sue.
Yep, there's the first 5 options, and there'll be another 5 coming shortly.
Okay. So there's certainly a lot going on.
Yeah. Okay, I will close and share those results. So in that list, we've got the majority around holiday pay and carers leave. Yeah,
Okay.
which is understandable, with some of the family stuff as well. Okay, I'll hide that and share the next one, which is part 2.
Yeah.
And this is around the other bits of law.
Interesting, isn't it? There's so much change to navigate.
Yeah. It's one of the biggest years, I think, isn't it, for change? Wow. I'm going to share those results. And here we go. So 90% flexible working. Yeah. And protection from redundancy. That's interesting.
I think the predictable terms and conditions is going to be an interesting piece of
law.
It is.
How that pans out in reality. Yeah, definitely.
And the other thing to sort of think about as well is it's almost certain this year is going to be an election year, and so we have the prospect of a potential change in government, and what changes therefore that could come with that. So we know, for example, if the government was to change, then 0-hour worker contracts, I think Labour was saying they would ban. So next year could be just as challenging.
Yeah, just as interesting.
Yeah.
Okay.
So that's it. And let's just move, I think, on to the final questions then before we go through to a few more slides.
So we have there was another flexible working request that came in, and it was asking how flexible working affects those working within the constraints of a school day. So I guess there's 2 ways of looking at it. I'm assuming it's somebody who works in a school environment and therefore they're restricted to those hours that the school's open. And from the school as an employer point of view, they'd have to just justify if it couldn't be worked flexibly, it would be down to sort of business reasons in quotes, because of the hours if they're in direct delivery of education, then maybe they've got the hours the children are there and needing to receive the education. But if they're in the school office or in a more administrative function, then there might actually be some more flexibility available, because the children present hours are different to the working day of the schools. So I guess that one will depend very much on the role and the specific requirements for flexible working. So yeah, that one would need looking into a bit specifically, I think. So do contractors also now have the right to request more predictable terms and conditions, or is it just employees? Somebody asked about agency workers as well.
Let me see where I can find on that.
So I wouldn't have thought contractors because they're self-employed.
Yeah.
So, but
I think agency. I'm just trying to find the code.
Agency workers who are employed by the agency, so they're employees of the agency, potentially.
Yeah,
I think they're excluded actually. I think they, yeah, we'd need to come back to you on those because this is a fairly new concept, yeah. So we're still exploring all the whys and wherefores of that one, but we will clarify those in the further information we send out. Excuse me. For the predictable terms and conditions, if we have set hours in our contracts, but many people operate flexibly outside of these with the manager's discretion, starting later, for example, can this give an opening to the team asking for more predictability? I guess it depends on how informal or formal those arrangements have become. Sounds more like flexible working in a way if it's regular, or by it could be a contractual change by implication, because the practice. So I think that what we're looking at really is how long it's been going on and how significant it was, how many people it affected, etc., etc.
Interesting.
Yes. So employee was invited to complete our flexible working request form a week ago, but hasn't submitted yet. If it's returned in early April, including the previous impact questions, etc., do we have to reissue a new form and start again? I guess it's when the request is received, isn't it? It's probably
on or after the 6th of April.
Yeah. So if it's received on or after the 6th, then you'd be into the new rules, but that's just the day one right at the moment.
Yes.
So who knows if the government confirm the rest of the regulations from the 6th of April, then you may be into following those. But if the request is received before, then I think you're under the current process, I would say, because it's requests received on or after, it will be, wouldn't it? Hence the date, the effective date. There is a question around protected characteristics. So it's more a sort of how can an employer navigate to protect the organisation when you have then go on to request reasonable adjustments when they have a related crisis or don't like the organisational response to the mass needs. So the law's pretty not really clear here, but I think isn't it when you become aware of if you are reasonably aware, yes, and so if it wasn't clear but now you do know, then you can only deal with the request once you know. If you could not have been reasonably expected to have known before and there was nothing on any medical disclosure or in any behavioural symptoms or any other where you would have known, because let's say it's masked, then in theory the employer could not have expected to have responded appropriately if they didn't know. So there is some requirement for an employee to make it clear the basis on which they request a change or request some kind of adjustment, because they need, as an employee, you need to know if it's within the Equality Act definitions, and therefore there are obligations, unless you're quite happy to make the change. But it's more about being able to give the employee the appropriate support, and if you don't know, then it's difficult to. So yeah, that's an interesting one. How often would this is another one on paying holidays now, I think. Yes, holiday pay. So how often would the employee need to work overtime for this to be classed as regular for the purpose of calculating normal remuneration when paying holiday pay? So
Oh, yeah, it's
this
hard,
is
isn't
down
it?
to the old definition as well, isn't it? In
That's
terms
what's
of
unclear.
regularity, and that's the bit we're waiting for a case ruling, isn't
Yeah,
it, to clarify. So yeah, and there's this thing about if it's in your contract that you will pay overtime, then there's a
yeah,
contractual obligation, so you would include it. If in custom and practice every month they work overtime, then or every week they work overtime, or they work overtime regularly,
mm,
whatever definition that is, then you would be more likely to have to include it than not. So you may want to accrue for it if you're not paying it.
yeah.
But that's the previous case law that threw that one, wasn't it, that into question.
Almost takes a little bit of, obviously you're going to need records to keep on top of managing all of this.
Yeah,
And it's
yeah,
almost like, so look back at, say, the last 100 days, not consecutive, but days worked. And out of those 100 days, mark out which ones they worked overtime. And then that helps you form a picture and an idea. It's gathering your data together to help you form that decision.
yeah. And just having justification, and in most cases, if your evidence steers you in one direction or another, then an employment tribunal is more likely to deem that you have investigated, you have acted as a reasonable employer in looking at the data and reaching a reasonable decision in the circumstances.
Yeah,
If you've got that evidence, then it's likely to be okay. It's if you've just said no and with no justification, or not really looked at it properly, or not really considered all options. So yeah, and I think it's some of the things about holiday pay is it is still going to be come out in case law like it has done
yeah.
this year after last year's.
It's
So
yeah,
yeah.
there's still questions, isn't there?
Get a bit more clarity each time, but we've still not got full clarity. But thank you. I think that's all the questions for
Okay,
now. We're
brilliant.
probably running out of time, so
Yeah,
we'll
we've got
leave
4
it there.
minutes. So there's a few more slides just to take everybody through. And it's just, first of all, let you know about our knowledge base. That's an online portal that if you are in a standalone role and you need that help with having ready available template HR documents, whether it's your letters, contracts, policies, as well as access to a lot of research and articles on the whole employee life cycle, then we offer that as a project that you can sign up to. We also offer lots and lots of training. As you can see here, this is just a variety of the training sessions that we run, all count towards CPD. And of course, we offer both ILM 3 and ILM 5. I think this year is definitely going to be a big year for training, because as I said earlier, line managers' roles are vital. And then for those of you who aren't regulars to our webinars, we actually run them every month in the second week, always generally a Thursday at 10 o'clock. And we've just published our latest schedule. So next month, we're going to be looking at how we can understand family leave a little bit more from a practical basis, not necessarily the techie legal side of it, but more the practical day-to-day use. Then in May, we're looking at the new rules on flexible working and predictable terms and conditions. So we're going to delve into those two areas in more detail. June is all about prioritising employee wellbeing. We all know that sickness absences are on the rise, especially in regards to stress-related absences. And then in July, we're going to be running a webinar to look more on that new law that's coming in, or the greater protection, should I say, for protecting employees from sexual harassment. So just visit our website to register. They're all free events. Or if you're a knowledge base user, then you can register via the knowledge base. And then coming soon, we're launching a white paper. So we have carried out our research and we've consolidated all of our expertise and professional thinking into one white paper called HR Thinking for 2024, aligning people and business strategy. So that's going to be launched very, very soon. So do keep an eye out on our social media platforms and obviously on our website. And that's a screenshot of what you can expect to see. And then just finally, before we close, we do like to follow up just to understand if there's anything that we can help you with moving forward, whether you do need our support with any of your employment documents, training, strategic planning, HR services, obviously retainer clients, helpline, etc. So do let us know and we can get in touch with you.
Just to stay on the strategic white paper, then we will be sending everybody who's registered for this webinar a link to the digital copy of it when it's released. So that's a treat for all those of you who've attended.
And we're sending the holiday toolkit out as well, did you say earlier?
That will be available. It'll certainly be available to clients, and I think we'll be adding it to our doc shop. Yeah, so. And we were giving you links to be able to access the resources and any of the useful links that we've mentioned, or additional information. And certainly the further information on the cases will be sent out as well. Okay, I will close that.
Brilliant.
Thank you. Continue.
Well, dead on 12 o'clock. I think that's a first, Sue. So just want to thank you for coming along to our annual virtual employment law seminar. It's so great to have our clients join us and people that are new to us and our sessions. So thank you for taking the time out. It is a busy year ahead, and if you do need any support or help, then just let us know. Thank you to Sue as well for co-delivering the seminar as well, and for your knowledge. It's been great. Thank you. So have a good day and wonderful Easter, everybody.
Thank you too.
Thank you.